So China, as a party to the International Covenant on Economic, Social, and Cultural Rights, has obligations to implement the convention in its territory, regardless of the status of the person. As long as the person is within the territory of China, um, China is responsible for the health of that person. Now, the interesting question, or rather the crux of the matter here, is does the application of the Covenant on Economic, Social, and Cultural Rights have extraterritorial value, or can it, in other words, can the obligations of China under the ICESCR have territorial effect? It's interesting to note that in the last decade or so, there has been a change in the notion of responsibilities of states under human rights law. Now, more or less, it is recognized that a state has responsibilities not only within its borders, not only within its territory, but even outside, as long as that territory outside of the state is within the effective control of the state concerned. And so we have to note, try to determine whether that particular patch of territory is, even though outside the territory of the concerned state, is within the effective control of that state, in the sense that either it has jurisdiction or it has control over the territory. That's a very high threshold, in a sense, to hold in this situation. Because, in my opinion, China doesn't have control over what is happening over the territory of the United States, for example, or of the Philippines, where the coronavirus is, or of Italy or any other country for that matter. Now, the nice thing to note, however, is that there could be another source. I'm saying could because this is not yet sure. It is an evolving matter as we speak. But there is probably another source of possible obligation on the part of China when it comes to the coronavirus spreading all over the world. And that is in the international health regulations of the World Health Organization. Now, China is also a party to the IHR of 2005. And the IHR of 2005 in Article 6 says that each state party shall assess events occurring within its territory by using the decision instrument in Annex 2. So there's an Annex to the convention or the treaty. Each state party shall notify the WHO by most effective means of communication available by way of the national IHR focal point and within 24 hours of assessment of public health information of all events which may constitute a public health emergency of international concern within its territory in accordance with the decision instrument. That's in part what the article says. The first paragraph. Now let's go to paragraph 2. Following a notification, a state party shall continue to communicate to WHO timely, accurate, and sufficiently detailed public health information available to it on the notified event, where possible including case definitions, laboratory results, source and type of risk, number of cases and deaths, etc. The question now is, was there timely notification on the part of China? There's also another possibly relevant article, Article 7, on information sharing during unexpected or unusual public health events. It says that if a state party has evidence of an unexpected or unusual public health event within its territory, irrespective of origin or source, which may constitute a public health emergency of international concern, it shall provide to WHO all relevant public health information. In such a case, the provisions of Article 6, the one that we just discussed previous to this, shall apply in full. So we see that there is this requirement for timely notification. Considering that, plus the Chorzo factory case or related and other related cases, on reparation, the essential principle, for example, contained in the Chorzo factory case is that the actual notion of an illegal act, a principle which seems to be established by international practice and in particular by the decisions of arbitral tribunals, is that a reparation must, as far as possible, wipe out all the consequences of the illegal act and reestablish the situation which would in all probability have existed had it not for the act. So that's the an important line in the Chorzo factory case. And related to this is also the case of the Rainbow Warrior case. Rainbow Warrior case tells us that the tribunal has to consider an order of payment for monetary compensation, then that could be made in respect of a breach of international obligations involving, as here, serious moral and legal damage, even though there is no material damage. So even if there's no material damage, a state could be held responsible for moral and legal damage. As I said, it still very much has to be determined whether China is in fact at fault, whether there was, delay in the notification, and whether the delay in the notification actually consisted in a violation of this convention, the WHO convention, and applying the principles of these cases which we just discussed, whether there is damage. Because it is only when there is damage that a state should be liable. Okay, so far so good. I hope you're somehow learning at the same time we're trying to grapple the issues together here. I hope so far helping you out understand some of the intricate legal issues at hand. And so far, what we've gathered are the possible, in essence, legal issues that can implicate China. Now we will go to the defenses, right? These are the things that I see that China could raise as possible defenses in this matter. Well, the first is the most obvious one, that China did not actually violate any legal obligation. In essence, as we said earlier, every state is liable for an internationally wrongful act. That is the heart of the matter of the Articles of State Responsibility. That's Article 1. And in Article 2, you have the two elements. So China can argue that I have not really violated any substantial obligation under international law, whether it be in the ICESCR, as far as human rights law is concerned, or in the international health regulations of 2005 of the WHO. Assuming further that there was some sort of problem, and this problem occurred in the territory of China, China could also additionally probably further the argument that Chinese authorities, state organs of China, were not involved at all in the alleged violations of international obligations. China could say that the actions originated from and were caused by private actors, and China did not commit anything wrong in the process. So that's the argument essentially that China can put forward as far as attributability is concerned. Now, I see some other arguments that China could raise. China could raise the argument that the burden of proof actually lies not on China but on other states to prove that China actually committed something wrong. And that those states should be able to prove that any damage were incurred, economic or otherwise, that the damage was in fact caused by China by a failure to act or an action of China was in violation of an international obligation. So we have an authority, the Trail Smelter case. It says that in page 1931 that with regard to damages in respect of business enterprises, in fact damages in general, the nature of the damage has to be proven for there to be reparations. So on the indemnity based on economic damages, the burden of proof lies on the one that alleges a violation. So another one that I see, a possible defense of China is that the damage caused was not something that China could have reasonably prevented. The damage to other countries is not something that China could have reasonably prevented. So the question there is a question of nexus. As we note in the Bosnian genocide case of 2007, the court actually said that the question of whether there is a sufficiently direct and certain causal nexus between the wrongful act and the breach, okay, that one has to really be proven. Such a nexus could be considered only, the court said, if the court were able to conclude from the case as a whole and with sufficient degree of certainty that the genocide, and the problem was, the matter at hand there was a genocide, would have in fact been averted if the state acted in compliance with its legal obligations. Now, China could probably argue that it could have not prevented this no matter what it does, because this is something that resulted from a biological cause or a epidemiological concern that is not within the hands of the state. So that's me basically reading the tea leaves for us here. As I said, a lot of legal scholars have shared and actually propounded views on the matter. Many of them I've compiled and talked to you before here. But I guess the issue here is this as well. Even if a state, as such as China, could be held liable, we have to find a state that would sue China, and it is in fact a political move on the part of the suing state. Now, human rights law could also be an avenue in the sense that not just before the ICJ, but before the committee, not before the ICJ, but before the Committee on Economic, Social, and Cultural Rights, there could be a complaint or a communication rather filed, essentially arguing that China was in breach of the provisions on the right to health in Article 12 of the ICESCR, or the right to health provision. Now, the value in that is the ICSCR committee can weigh in and propound views on the matter. It could rule on the extraterritorial nature of the obligations of China, but unfortunately, it cannot really enforce payment because the judgments, not judgments rather, but the views of the committee are not really enforceable in that sense. So, all right. I hope I was able to enlighten you as to the issues that are surrounding us right now on the right to health and state responsibility. Thank you very much for listening.